Plaintiff, the People of the State of New York, by Letitia James, Attorney General of the State of New York, as and for their verified complaint, respectfully allege: 1. Nature of the action. 1. Following a comprehensive 3-year investigation by the Office of the Attorney General, or OAG, involving interviews with more than 65 witnesses and review of millions of pages of documents produced by defendants and others, OAG has determined that defendants Donald J. Trump, Mr. Trump, Trump Organization LLC, and the Trump Organization, Inc., collectively with the other named entities, the Trump Organization, Alan Weisselberg, and the other individuals and entities affiliated with Mr. Trump and his companies named as defendants, engaged in numerous acts of fraud and misrepresentation in the preparation of Mr. Trump's annual statements of financial condition, or statements of financial condition or statements, covering at least the years 2011 through 2021. 2. These acts of fraud and misrepresentation were similar in nature, were committed by upper management at the Trump Organization as part of a common endeavor for each annual statement, and were approved at the highest levels of the Trump Organization, including by Mr. Trump himself. Indeed, Mr. Trump made known through Mr. Weisselberg that he wanted his net worth on the statements to increase, a desire Mr. Weisselberg and others carried out year after year in their fraudulent preparation of the statements. 3. These acts of fraud and misrepresentation grossly inflated Mr. Trump's personal net worth as reported in the statements by billions of dollars and conveyed false and misleading impressions to financial counterparties about how the statements were prepared. Mr. Trump and the Trump Organization used these false and misleading statements repeatedly and persistently to induce banks to lend money to the Trump Organization on more favorable terms than would otherwise have been available to the company, to satisfy continuing loan covenants, and to induce insurers to provide insurance coverage for higher limits and at lower premiums. 4. All of this conduct was in violation of New York Executive Law Section 63(12)'s prohibition of persistent and repeated business fraud, which embraces any conduct that has the capacity or tendency to deceive or creates an atmosphere conducive to fraud. 5. These misrepresentations also violated a host of state criminal laws, constituting repeated and persistent illegality in violation of Executive Law Section 63(12). Among other laws, defendants repeatedly and persistently violated the following: New York Penal Law Section 175.10, falsifying business records; Penal Law Section 175.45, issuing a false financial statement; and Penal Law Section 176.05, insurance fraud. 6. Each statement from 2011 to 2021 provides Mr. Trump's personal net worth as of June 30th of the year it covers, was compiled by Trump Organization executives, and was issued as a compilation report by Mr. Trump's accounting firm. Each statement provides on its face that its preparation was the responsibility of Mr. Trump, or, starting in 2016, the trustees of his revocable trust, Donald Trump Jr. and Alan Weisselberg. Each statement was personally certified as accurate by Mr. Trump, by one of his trustees, or in 2021 by Eric Trump, when submitting the statement to financial institutions with the purpose and intent that the information contained in the statement would be relied upon by those institutions. 7. Each year from 2011 to 2016, Mr. Trump and Mr. Weisselberg would meet to review and approve the final statement. When asked questions about those meetings under oath, both men invoked their Fifth Amendment privilege against self-incrimination and refused to answer. When asked under oath if he continued to review and approve the statements after becoming President of the United States in 2017, Mr. Trump invoked his Fifth Amendment privilege and refused to answer. 8. As further evidence of their scheme to inflate the value of Mr. Trump's assets when beneficial to his financial interests, Mr. Trump and the Trump Organization procured inflated appraisals through fraud and misrepresentations in 2014 and 2015 for the purpose of granting conservation easements over two of Mr. Trump's properties. Through these conservation easements, Mr. Trump and the Trump Organization agreed to forego their purported rights to develop areas of the two properties that are the subjects of the easements, which enabled them to treat as a charitable donation the difference in the value of each property with and without the relinquished development rights as determined in the appraisals. In the same way that Mr. Trump and the Trump Organization inflated the valuations of Mr. Trump's assets for the statements, they manipulated the appraisals to inflate the value of the donated development rights with respect to both conservation easements. A. The fraudulent statements of financial condition. 9. Each statement of financial condition lists Mr. Trump's assets and liabilities, and then presents his net worth as the difference between the two. On the asset side, each statement includes 5 basic categories. 1. Cash and cash equivalents. 2. Monies held in escrow and reserve deposits. 3. Interests in partnerships and joint ventures. 4. Real estate licensing fees. And 5. By far the largest category, real estate holdings. On the liability side, each statement lists accounts payable and accrued expenses, loans on real and operating properties, and other mortgages and loans. 10. Mr. Trump's statements of financial condition for the period 2011 through 2021 were fraudulent and misleading in both their composition and presentation. The number of grossly inflated asset values is staggering, affecting most, if not all, of the real estate holdings in any given year. All told, Mr. Trump, the Trump Organization, and the other defendants, as part of a repeated pattern and common scheme, derived more than 200 false and misleading valuations of assets included in the 11 statements covering 2011 through 2021. 11. Nearly every one of the statements represented that the values were prepared by Mr. Trump and others at the Trump Organization in evaluations done with outside professionals. But that was false and misleading. No outside professionals were retained to prepare any of the asset valuations presented in the statements. To the extent Mr. Trump and the Trump Organization received any advice from outside professionals that had any bearing on how to approach valuing the assets, they routinely ignored or contradicted such advice. For example, they received a series of bank-ordered appraisals for the commercial property at 40 Wall Street that calculated a value for the property at $200 million as of August 1, 2010, and $220 million as of November 1, 2012. Yet in the 2011 statement, they listed 40 Wall Street with a value of $524 million and increased the valuation to $527 million in the 2012 statement and to $530 million in 2013, more than twice the value calculated by the professionals. Even more egregiously, the valuation of more than $500 million was attributed to information obtained from the same professional appraiser who prepared both valuations, putting the building's value at or just over $200 million. 12. The inflated asset valuations in the statements cannot be brushed aside or excused as merely the result of exaggeration or good faith estimation about which reasonable real estate professionals may differ. Rather, they are the result of the defendants utilizing objectively false assumptions and blatantly improper methodologies with the intent and purpose of falsely and fraudulently inflating Mr. Trump's net worth to obtain beneficial financial terms from lenders and insurers. 13. Nor can the false and fraudulent asset values in the statements be defended based on boilerplate disclaimers in the accountant's compilation report accompanying each statement. While the accountants gave notice in the reports that they did not audit or review the statements to verify the accuracy or completeness of the information provided by Mr. Trump or the Trump Organization, they confirmed that their clients were responsible for preparing the statements in accordance with generally accepted accounting principles in the United States, GAAP. The disclaimers may relieve the accountants of certain obligations that would otherwise adhere to their work on a more rigorous audit engagement, but they do not give license to Mr. Trump or the Trump Organization to submit to their accountants fraudulent and misleading asset valuations for inclusion in the statements. 14. Moreover, Mr. Trump and the Trump Organization have no excuse for issuing statements of financial condition that repeatedly violated GAAP rules in multiple ways, despite expressly representing in the statements that they were prepared in accordance with GAAP. Among the many GAAP rules they violated are 1. Including as cash funds that Mr. Trump could not immediately liquidate because they did not belong to him and may never be distributed to him. 2. Failing to determine the present value of projected future income when including the income as part of an asset valuation. 3. Failing to disclose a substantial change in methodology from the prior year's statement for how an asset value was derived. 4. Failing to value the entirety of Mr. Trump's interest in a partnership, including all limitations and restrictions on his interest. And 5. Including intangibles such as internally generated brand premiums when calculating an asset's value. 15. As discussed in greater detail in the sections that follow, Mr. Trump and others affiliated with the Trump Organization who are named as defendants employed a number of deceptive strategies as part of the overall scheme to fraudulently and falsely inflate Mr. Trump's assets in order to comply with Mr. Trump's instructions to increase his net worth. A chart showing many of the deceptive strategies employed by Mr. Trump and other defendants by asset and year is attached as Exhibit 1 and includes the following, to list just a few. A. Relying on objectively false numbers to calculate property values. For example, Mr. Trump's own triplex apartment in Trump Tower was valued as being 30,000 square feet when it was 10,996 square feet. As a result, in 2015, the apartment was valued at $327 million in total, or $29,738 per square foot. That price was absurd given the fact that at that point only one apartment in New York City had ever sold for even $100 million, at a price per square foot of less than $10,000. And that sale was a newly built, ultra-tall tower. In 30-year-old Trump Tower, the record sale as of 2015 was a mere $16.5 million at a price of less than $4,500 per square foot. B. Ignoring legal restrictions on development rights and marketability that would materially decrease property values. For example, 1. In the 2012 statement, rent-stabilized apartments at Trump Park Avenue were valued as if they were unrestricted, leading to a nearly $50 million valuation for those units. but an appraisal accounting for those units' stabilized status valued them collectively at just $750,000. 2. The Mar-a-Lago Club was valued as high as $739 million based on the false premise that it was unrestricted property and could be developed and sold for residential use, even though Mr. Trump himself signed deeds donating his residential development rights and sharply restricting changes to the property. In reality, the club generated annual revenues of less than $25 million and should have been valued at closer to $75 million. And 3, for his golf course in Aberdeen, Scotland, the valuation assumed 2,500 homes could be developed when the Trump Organization had obtained zoning approval to develop less than 1,500 cottages and apartments, many of which were expressly identified as being only for short-term rental. The $267 million value attributed to those 2,500 homes accounted for more than 80% of the total $327 million valuation for the Aberdeen property on the 2014 statement. C. Failing to use basic rules of valuation to ensure reliable and accurate results, such as discounting revenue or cash flow that might be obtained from a speculative development far into the future to its present value. For example, a series of high-value properties estimated the profits from developing and selling homes without accounting for the years it would take to plan, build, and sell the homes, and instead operated under the impossible and thus false premise that the homes could be planned, built, and sold instantaneously. D. Using an inappropriate valuation method for a given category of assets. For example, for the period 2013 to 2020, Mr. Trump's golf course in Jupiter, Florida, was valued using a fixed asset approach, even though that was not an acceptable method for valuing an operating golf course. And the bulk of the value in that fixed asset approach was based on the use of an inflated purchase price from the purported assumption of refundable membership liabilities. Mr. Trump claimed to have paid $46 million for the club, consisting of $5 million in cash he actually paid and $41 million in assumed membership liabilities. In the statement, Mr. Trump did not disclose the inclusion of those inflated liabilities in the price of the club and, in fact, took the opposite position, stating that his potential liability for those membership deposits was zero. E. Increasing the value of golf clubs to incorporate a brand premium despite expressly advising in the statements that brand value was not included in the figures and despite GAAP rules prohibiting inclusion of internally generated intangible brand premiums. For example, in the 2013 statement, the value of Mr. Trump's golf course in Jupiter, Florida, was further inflated by fraudulently adding 30% for the Trump brand. Combining the inflation from using the fixed asset approach with the 30% brand premium, Mr. Trump claimed that a club he purchased for $5 million in 2012 was worth more than $62 million in 2013. The 2013 statement included the same fraudulent 30% brand premium for 6 other golf clubs. F. Using inflated net operating income or NOI figures and arbitrarily low capitalization rates to calculate valuations using the income capitalization method, where value is derived by dividing NOI by a capitalization rate. For example, in some instances, the NOI for Trump Tower relied on favorable numbers by mixing time periods, using future income that exceeded the Trump Organization's internal budget projections, while also using expense figures that were lower than past expenses in audited financials. Capitalization rates were derived by cherry-picking an unsupported figure from, or averaging the lowest 2 or 3 capitalization rates listed in, generic marketing reports and ignoring rates in those same reports for buildings that were closer and more comparable to Trump Tower. G. Claiming as Mr. Trump's own cash monies belonging not to Mr. Trump, but to partnerships in which Mr. Trump had only a limited partnership interest with no control over making disbursements. For example, 1/3 of the amount under cash and cash equivalents listed in the 2018 statement belonged to Vornado Partnerships, not Mr. Trump. Those are partnerships in which he owns a minority 30% stake with no right to control distributions. Mr. Trump did the same thing in counting funds held in escrow. For example, 1/2 of the amount under escrow in the 2014 statement belonged to the Vornado Partnership. H. Including in the value of golf clubs anticipated income from inflated membership initiation fees. For example, at Mr. Trump's golf course in Westchester, the valuation for 2011 assumed new members would pay an initiation fee of nearly $200,000 for each of the 67 unsold memberships, even though many new members in that year paid no initiation fee at all. In some instances, Mr. Trump specifically directed club employees to reduce or eliminate the initiation fees to boost membership numbers. 16. Mr. Trump and the other defendants also engaged in conduct intended to mislead Mazars in connection with its work compiling the statements, including by concealing important information. Because Mazars was not conducting any review or audit procedures, but rather issuing a compilation in which Mr. Trump's and the trustees' assertions were being compiled into financial statement format, many of their fraudulent statements and strategies remained concealed from or undetected by Mazars. 17. As a result, shortly after some of the findings uncovered by OAG's investigation came to light in public filings to enforce OAG's investigative subpoenas, Mazars concluded that it had to end its long-term business relationship with Mr. Trump and the Trump Organization and withdraw the statements it had compiled from 2011 to 2020. In a letter to the Trump Organization dated February 9, 2022, Mazars explained that it had come to this conclusion based in part upon the filings made by the New York Attorney General on January 18, 2022. Our own investigation, and information received from internal and external sources, and advised that the statements of financial condition for Donald J. Trump for the years ending June 30, 2011 through June 30, 2020 should no longer be relied upon. Mazars further instructed the Trump Organization to inform any recipients thereof who are currently relying upon one or more of those documents that those documents should not be relied upon. 18. Mr. Trump's statements of financial condition were repeatedly and persistently submitted to banks insured by the Federal Deposit Insurance Corporation for the purpose of influencing the actions of those institutions. The statements were used to obtain and maintain favorable loans over at least an 11-year period, including a Deutsche Bank's extension of a $125 million loan, or combination of loans, in connection with the Trump Organization's purchase of the property known as Trump National Doral. B. Deutsche Bank's financing of up to $107 million in debt in connection with the Trump International Hotel and Tower, Chicago, in 2012, as well as a $54 million expansion of that loan in 2014, and C. Deutsche Bank's financing of up to $170 million in funds in connection with the Trump Organization's purchase and renovation of the old post office property in Washington, D.C. 19. As to each of those loans, the truthfulness and accuracy of the pertinent statement, as certified by Mr. Trump, was a precondition to lending. Moreover, pursuant to the covenants of those loans, each year Mr. Trump or the trustees would submit a new statement and certify its accuracy. Material misrepresentations on any loan document, including the statements or the certifications as to their accuracy, would constitute an event of default under the terms of the loan agreements. 20. The statements, along with other false representations, were also used repeatedly and persistently to obtain beneficial terms on insurance policies from insurers participating on the Trump Organization's surety program and directors' and officers' liability policies. 21. The magnitude of financial benefit derived by Mr. Trump and the Trump Organization by means of these fraudulent and misleading submissions was considerable. Following the initiation of subpoena enforcement litigation against Mr. Trump and Mazar's withdrawal of 10 years' worth of Mr. Trump's statements of financial condition, Mr. Trump and the Trump Organization decided to repay hundreds of millions of dollars in debt early. But even that step, the equivalent of partial disgorgement, fails to account for substantial additional financial benefit obtained by Mr. Trump and the Trump Organization by means of the false and fraudulent statements of financial condition. Mr. Trump and his operating companies obtained additional benefits from banks other than loan proceeds in the form of favorable interest rates that likely saved them more than $150 million over the prior 10-year period. 22. The statements were also critical to the overall success of the investment in the old post office property in Washington, D.C. Based on its own statement, the Trump Organization won the bidding as part of one of the most competitive selection processes in the history of the General Services Administration. Critical to the success of that bid was a demonstration of the financial wherewithal of the Trump Organization through the submission of his Statement of Financial Condition. The favorable interest rates obtained from Deutsche Bank were instrumental in the financial performance of the investment, which ultimately led to the record-breaking sale of the Trump International Hotel, Washington, D.C., and a financial benefit to the Trump Organization of more than $100 million in May 2022. 23. All of those benefits were derived from the improper, repeated, and persistent use of fraudulent and misleading financial statements and are therefore subject to disgorgement in this action under Executive Law Section 6312. 24. It is no defense to claims for disgorgement under Section 6312 that the Trump Organization may have made all payments due under the loans and insurance policies. The remedy of disgorgement is available to deprive a wrongdoer of illegal benefit regardless of whether any entity suffered a financial loss. B. Relief sought. 25. In this proceeding, the people seek an order and judgment granting the following relief to remedy the substantial, persistent, and repeated fraudulent and misleading conduct occurring since 2011. A. Canceling any certificate filed under and by virtue of the provisions of Section 130 of the New York General Business Law for the corporate entities named as defendants and any other entity controlled by or beneficially owned by Donald J. Trump, which participated in or benefited from the foregoing fraudulent scheme. B. Appointing an independent monitor to oversee compliance, financial reporting, valuations, and disclosures to lenders, insurers, and governmental authorities at the Trump Organization for a period of no less than 5 years. C. Replacing the current trustees of the Donald J. Trump Revocable Trust with new independent trustees, and requiring similar independent governance in any newly formed trust should the revocable trust be revoked and replaced with another trust structure. D. Requiring the Trump Organization to prepare a GAAP-compliant, audited statement of financial condition audited by an independent auditing firm empowered to retain independent valuation personnel showing Mr. Trump's net worth, to be distributed to all recipients of his prior statements of financial condition, with any statements of financial condition prepared for the next 5 years to also be subject to a GAAP-compliant audit. E. Barring Mr. Trump and the Trump Organization from entering into any New York State commercial real estate acquisitions for a period of 5 years. F. Barring Mr. Trump and the Trump Organization from applying for loans from any financial institution chartered by or registered with the New York Department of Financial Services for a period of 5 years. G. Permanently barring Mr. Trump, Donald Trump Jr., Ivanka Trump, and Eric Trump from serving as an officer or director in any New York corporation or similar business entity registered and or licensed in New York State. H. Permanently barring Alan Weisselberg and Jeffrey McConney from serving in the financial control function of any New York corporation or similar business entity registered and or licensed in New York State. I. Awarding disgorgement of all financial benefits obtained by each defendant from the fraudulent scheme, including all financial benefits from lenders and issuers through repeated and persistent fraudulent practices of an amount to be determined at trial, but estimated to be $250 million plus prejudgment interest, and J. Granting any additional relief the court deems appropriate. Part 2. The Parties. 26. The Attorney General is responsible for overseeing the activities of New York businesses and the conduct of their officers and directors in accordance with the New York executive law and other applicable laws. She is expressly tasked by the legislature with policing any persistent or repeated fraud and illegal conduct in business. 27. Defendant Donald J. Trump is the beneficial owner of the collection of entities he styles the Trump Organization. Approximately 500 separate entities collectively do business as the Trump Organization and operate for the benefit and under the control of Donald J. Trump. Among the entities that comprise the Trump Organization are A. Defendant Trump Organization, Inc. From May 1, 1981 to January 19, 2017, Mr. Trump was Director, President, and Chairman of the Trump Organization, Inc. From at least July 15, 2015 until May 16, 2016, Mr. Trump was the sole owner of the Trump Organization, Inc. B. Defendant Trump Organization, LLC, a limited liability company doing business in the state of New York with a principal place of business in New York, New York. C. Defendant DJT Holdings, LLC, a Delaware limited liability company with a principal place of business in New York, New York. D. Defendant DJT Holdings Managing Member, a Delaware limited liability company registered to do business in New York, New York. 28. In addition, the Trump Organization incorporates a host of entities that either own property at issue in this action or received loans at issue in this action. Included among those entities are A. Defendant Trump Endeavor 12 LLC, a Delaware limited liability company registered to do business in New York, New York. Trump Endeavor 12 LLC owns the resort property doing business as Trump National Doral. B. Defendant 401 North Wabash Venture LLC, a Delaware limited liability company that operates out of the Trump Organization offices in New York, New York. 401 North Wabash Venture LLC owns the building doing business as Trump International Hotel and Tower, Chicago. C. Defendant Trump Old Post Office LLC, a Delaware limited liability company with its principal place of business in New York, New York. Trump Old Post Office LLC held a ground lease from the federal government to operate the property doing business as the Trump International Hotel, Washington, D.C. D. Defendant 40 Wall Street LLC, a New York limited liability corporation which holds a ground lease for an office building located at 40 Wall Street, New York, New York. E. Respondent Seven Springs LLC is a New York limited liability company that owns the Seven Springs estate, consisting of 212 acres of property within the towns of Bedford, Newcastle, and North Castle in Westchester County, New York. 29. Donald J. Trump served as the president and chairman of the Trump Organization from May 1, 1981 to January 19, 2017. While serving as President of the United States, Mr. Trump remained the inactive president of the Trump Organization. After leaving office, Mr. Trump resumed his position as the president of the Trump Organization. 30. Defendant Donald J. Trump Revocable Trust is a trust created under the laws of New York that is the legal owner of the entities constituting the Trump Organization. The Donald J. Trump Revocable Trust was created on April 7, 2014, and amended by Second Amendment to the trust dated January 17, 2017. The purpose of the trust is to hold assets for the exclusive benefit of Donald J. Trump. Mr. Trump is the sole beneficiary of the Donald J. Trump Revocable Trust. 31. A complete organizational chart of the entities held by the Donald J. Trump Revocable Trust that was prepared by the Trump Organization in 2017 for the purposes of obtaining insurance coverage is attached as Exhibit 2. 32. Defendant Donald Trump Jr. is an executive vice president of the Trump Organization. He maintains a business office at 725 Fifth Avenue, New York, New York. Donald Trump Jr. oversees the Trump Organization's property portfolio and is involved in all aspects of the company's property development, from deal evaluation, analysis and pre-development planning to construction, branding, marketing, operations, sales, and leasing. Donald Trump Jr. is also responsible for all of the commercial leasing for the Trump Organization, which includes Trump Tower and 40 Wall Street. 33. Defendant Ivanka Trump was an executive vice president for development and acquisitions of the Trump Organization through early January 2017. Among other responsibilities, Ms. Trump negotiated and secured financing for Trump Organization properties. While at the Trump Organization, she directed all areas of the company's real estate and hotel management platforms. This included active participation in all aspects of projects, including deal evaluation, pre-development planning, financing, design, construction, sales, and marketing, as well as involvement in all decisions relating to those activities, large and small. Among other duties, she negotiated the lease with the government and a loan related to the old post office property. Ms. Trump also negotiated loans on Trump Organization properties at Doral and Chicago. On each of those transactions with Deutsche Bank, Ms. Trump was aware that the transactions included a personal guarantee from Mr. Trump that required him to provide annual statements of financial condition and certifications. 34. After leaving the Trump Organization, Ms. Trump retained a financial interest in the operations of the Trump Organization through a number of vehicles, including an interest in the old post office property through Ivanka OPO LLC. In a 2021 federal filing, Ms. Trump reported total income from Trump Organization entities of $2,588,449, including income from Ivanka OPO LLC, TTT Consulting LLC, TTTT Venture LLC, and Trump International Realty. 35. Defendant Eric Trump is an executive vice president of the Trump Organization and chairman of the advisory board of the Donald J. Trump Revocable Trust. He maintains a business office at 725 Fifth Avenue, New York, New York. Eric Trump is responsible for all aspects of management and operation of the Trump Organization, including new project acquisition, development, and construction. Eric Trump actively spearheaded the growth of Trump Golf, including the addition of 13 golf properties since 2006. 36. Defendants Donald Trump Jr. and Eric Trump took over management of the Trump Organization from Mr. Trump in 2017. 37. Defendant Alan Weisselberg was the chief financial officer of the Trump Organization from 2003 until July 2021. During that time, he maintained a business office at 725 Fifth Avenue, New York, New York. Among his responsibilities as CFO, from at least 2011 until 2020, Mr. Weisselberg supervised and approved the preparation of the valuations contained in the statements of financial condition. 38. Defendants Donald Trump Jr. and Alan Weisselberg were trustees of the Donald J. Trump Revocable Trust until Mr. Weisselberg resigned in June 2021. On information and belief, Donald Trump Jr. is now the sole trustee of the Donald J. Trump Revocable Trust. Donald Trump Jr. is named in both his personal capacity and as the trustee of the Donald J. Trump Revocable Trust. 39. Defendant Jeffrey McConney is the controller of the Trump Organization. He maintains a business office at 725 Fifth Avenue, New York, New York. Among his responsibilities as controller, from 2011 to 2016, Mr. McConney prepared the valuations contained in the statements of financial condition. From 2016 to the present, Mr. McConney supervised and approved the preparation of the valuations contained in the statements of financial condition. Part 3. Jurisdiction, applicable law, and venue. 40. This enforcement action is brought on behalf of the people of the State of New York pursuant to the New York Executive Law. 41. Executive Law Section 6312 allows the Attorney General to bring a proceeding whenever any person shall engage in repeated, fraudulent, or illegal acts, or otherwise demonstrate persistent fraud or illegality in the carrying on, conducting, or transaction of business. 42. Fraudulent conduct as used in Section 6312 includes acts that have the capacity or tendency to deceive or creates an atmosphere conducive to fraud. The terms fraud and fraudulent are given a wide meaning so as to embrace all deceitful practices contrary to the plain rules of common honesty, including all acts, even though not originating in any actual evil design to perpetuate fraud or injury upon others, which do tend to deceive or mislead. By its plain terms, Executive Law Section 6312 covers frauds committed by overtly false or fraudulent statements, by omission, or as part of a scheme to defraud. 43. A violation of any federal, state, or local law or regulation constitutes illegality within the meaning of Executive Law Section 6312. It long has been recognized that the statute affords the Attorney General broad authority to enforce federal as well as state law unless state action in the area of federal concern has been precluded utterly or federal courts have exclusive jurisdiction of the matter. Thus, if conduct violates a provision of New York's penal law, it may be the subject of an action for equitable relief on the basis of illegality under Executive Law Section 6312. 44. State laws other than Executive Law Section 6312 render unlawful certain fraudulent actions with respect to financial statements and their use. Falsification of business records is unlawful under the penal law and is a felony when committed to aid or conceal the commission of another offense. The issuance of a false financial statement is likewise an offense under the penal law. A conspiracy, essentially an agreement to commit an offense by a group of persons and one overt act by one of the conspirators, is unlawful under the penal law as well. 45. Fraud or illegality within the meaning of Executive Law Section 6312 may be the subject of an enforcement action if it is either repeated or persistent. Such conduct is repeated, Section 6312 instructs, if it involves either any separate and distinct fraudulent or illegal act or conduct which affects more than one person. Thus, under the statute, the Attorney General may bring a proceeding when the respondent was guilty of only one act of alleged misconduct, providing it affected more than one person. 46. The statute instructs that the term persistent includes the continuance or carrying on of any fraudulent or illegal act or conduct. 47. Among the equitable remedies available to the Attorney General under Executive Law Section 6312 is disgorgement, which is designed to deprive the wrongdoer of a legal benefit regardless of whether any entity suffered a financial loss. Multiple defendants may be jointly and severally liable for disgorgement under Section 6312 when they have participated in a common scheme. Disgorgement can also include salary and bonuses that are a result of fraudulent activity. 48. This court has jurisdiction over the subject matter of this action, personal jurisdiction over the defendants, and authority to grant the relief requested pursuant to Executive Law Section 6312. 49. Pursuant to CPLR Section 503, venue is proper in New York County because plaintiff resides in that county, and because a substantial part of the events and omissions giving rise to the claims occurred in that county. We've come to the end of parts 1 through 3. Next episode picks up with factual allegations in Part 4 of the complaint.